The Digital Personal Data Protection Act has been a long time coming. The first time I was involved in a data protection law was now 12, 14 years ago, and we are literally on the home stretch, which is we now have the data protection rules that has been released for public consultation. Detailed consultations have taken place. The consultation period has closed, and now we are waiting the final rules. And once the final rules are announced, we have a complete law. At that point in time, personal data will be protected in India through a formal law. I keep telling people that it has always been protected because we have a 9-judge Supreme Court bench that articulates the right to privacy, so it's not like we're living in a vacuum. But now we have the specifics. And I think through this whole process, of course, we've done this many times in GTS, and I almost feel like this panel is one of those, why are we singing the song after the audience has left? But it nevertheless is an important time to reflect on what is happening right now, what will happen, any gaps, any things that we should be thinking about even now when we've got a near complete law, and most importantly, what immediate next steps are. So Bhuvnesh ji will join us, and he's been involved in a lot of the nitty-gritties and details of getting the law to this stage. He obviously is going to be very crucial in the immediate next steps and what is going to happen after that. But I thought we'd just kick the panel off by doing a sort of a state of play for all the entities here. And we have represented on stage the financial sector, the e-commerce sector, civil society, and social media. And as you can imagine, that all of these have different perspectives on the issue of data protection, and in particular on the way in which the new law interacts with their sector. So, Sahani, I'm going to start with you from the financial sector. I guess if there is a sector that is like a sort of a classically traditional sector that is very digitized, it is the financial sector. It is probably the most advanced in its state of digitization. And this is not including India's digital payment infrastructure. Even before that, it is a deeply digitized sector. So I just want to start with what is the impact of DPDP going to be on fintechs and the financial sector at large? And I want to save some time up for another question around the digital public infrastructure framework and account aggregators. But if you could just start with how fintechs in the financial sector will be changed once the DPDP Act comes into force.
Yeah. No, thank you for that, Rahul, and good afternoon, everyone. As you rightly said, the financial sector in India is not only the most digitized or the most mature ecosystem, it's also the most deeply regulated one. And I think more than as industry, as citizens, we can all take a lot of comfort in the fact that it is deeply governed. The pros and cons are a concept for a different conversation, but there is already substantial thought that has been put towards individual rights and data governance in the financial sector. In some ways, especially RBI regulated entities, I can speak to them as being one part of it myself. I think the delta as a result of the Data Protection Act would be least for a financial sector entity compared to many other sectors, for the fact that already there are several laws, regulations, and governance structures in place which are impacting the sector today. This ranges right from something as cursory as the co-branded guidelines of RBI, which already put in place consent artifact or consent-based data sharing to partners in the ecosystem, to even the audits that banks undergo on a daily basis, on an annual basis, which is governing their data movement and the permissions they seek as a result. So yes, it's not that there is a zero impact, but it is not a complete 0 to 1 game. There is already a lot of systems in place. Consent is not an alien term in the financial sector. It is an understood concept. It is where a lot of governance has already happened. And I think there are already several advanced data structures such as account aggregator, which we definitely should talk about in a bit, which are already that the financial sector is already comfortable with to a large extent. There are some bits on information security and data movement that will still have to be put in place, but I think by and large, the financial sector is definitely one of the few sectors I would argue is mostly already in a good place.
So, I mean, I don't disagree that the financial sector is very well regulated, but at least from a data protection perspective, I feel that all the data protection violations that are inflicted on me today are by banks calling me to sell me a loan or to tell me that I'm eligible for some kind of insurance or something like that.
Sure.
My sense is that the entire banking sales industry is built on a business model that's designed to violate data protection. They buy large amounts of personal data and then they use the numbers to call me. I mean, you're not a bank, so I'm not like, it's not directly leveled at you.
I'm not batting
but
to anybody today.
I'm just saying that the point I'm trying to make is that the way we do business traditionally is going to change once this law comes into force. And even a sector that is highly regulated, like the banking sector,
Sure.
In its day-to-day functions, I think I agree with you 100%, that they're completely compliant. But in some areas, particularly the sales and marketing, will probably have to make some changes. And my question to you is, how ready are the banks for that? How well has that percolated into the system?
Right. No, I completely agree with you. And I would put this in 2 to 3 different buckets, right? One is core banking functions and how data moves within the core banking function, how your transaction data, your payment data is evaluated, governed, and regulated is, let's say, one core piece that there is adequate scaffolding over. But the second part you're referring to, which is, let's say, broadly put, ad sales and marketing, I think 3 out of 4 people on this stage have a perspective on that and are in the middle of it. Just as globally, all marketing and ad sales has gone through a change since data governance laws have come into place, definitely. Any sort of ads that are made in the financial sector will also have to go through that. There is sensitivity around financial sector ads on other axes. For example, that insurance should not be openly solicited, that there are other reasons for that in place. Suitability, appropriateness of financial products has been in place for a very long time, whether it is in SEBI financial products, appropriateness, risk profiling, and so on and so forth. And then when you're saying putting additional factors into place on loans, assessing creditworthiness, the groundfold of that, which has been in place in the financial sector, I would argue is not there anywhere else anyway. In terms of the solicitation that you're referring to, which is, a loan call or a credit card call, I'm not going to say it's the more benign version, but is not completely uncommon in as much as an internet ad comes out to you. This is going to be an ad on a telephone. Annoying for sure. As we all know, there will be a way in which we can seek consent for that also, where they will say, oh, you've consented to having people reach out to you. But I think for all of these reasons, the harms of getting unsuitable products coming out to you, I think is the major harm or the major concerns of where your data is going to be used. And I think that the financial sector has put in a safety valve which is unheard of. Across many parts of the world, I would say they don't have such strong safeguards. So along those lines, it's taken care of. The nuisance value and the unsavory parts, I think it'll die down eventually.
Okay. Aman, I want to come to you once again with a similar kind of a question around how is the e-commerce industry aligned with this. But I want to do it particularly from the perspective of the fact that global corporations that are dealing with personal data as even some part of what they're doing have to do this in a sort of a unified way across the entire ecosystem for many reasons. Some of the things that we buy on Amazon India have come from different parts of the world where there are different data protection laws, and you can't be dividing this up into many countries. So there is a need for some uniformity across the world. And India's data protection law is not like a GDPR style law, but it is very heavily inspired by GDPR, and so we were quite pleased that there is going to be some consensus of principles, at least, across many jurisdictions. I just want you to reflect on that a bit to see if, in fact, that is true. Are there things that we will still have to do differently in India because of the way the Indian law has been framed? And if you can think through some of the examples, perhaps around grounds of processing and things like that, to an audience that's perhaps not an expert in data protection, if you could break it down in a simpler way and explain how there would be challenges for a global corporation complying with DPDP.
Thank you. Firstly, thank you for having me here. Like what Rahul said, I've also had the pleasure of working on this topic for many, many years, and I can't think of a better topic.
Some people
right
don't
after.
say it's a pleasure. I think it's divided in this.
Yeah, the outcome is. But I can't think of a better topic right after lunch. So and to see a fully packed room discussing data, which we seem to have been doing for a decade and a half. It is before I start, I do want to say that I think where we are today is a reasonably good place and a much better place than some of the places we were looking at possibly ending up in, right? This is 2017, 2018, 2019. So where we are, so I think it is at that stage where it's almost a good problem to have, that because things have become clearer over a period of time. So I'll give you a very, Rahul spoke of examples, so I'll give you an example. When the Act came out, a lot of us in the industry said, look, this is progressive, this is different. It is definitely, when it started, it was GDPR++. Eventually, it became something which is somewhat similar, but definitely a different model than GDPR. When the details came out and the rules came out, suddenly the government announced that there'll be a committee that will decide on what data subjects can be or topics can be under data localization rules. Now, in the Act, there is no mention of the committee. Suddenly there was a committee. We needed to figure out, what that meant and so on. So there are things that have now come up that have become very specific and clear. Like as an example, it requires e-commerce companies to automatically delete data for a data principal after 3 years. So let's say you've gone on Amazon, you bought something today, and come 2027, we are required to delete your data if you've been inactive in that period. Now, practically what ends up happening is we have enough use cases of folks coming back because they want to see if the warranty still exists for a TV they bought 5 years back, right? Or they just want to know the model. You don't remember it. You bought something. I had this thing, very conveniently as an example. I had a thing very recently where I wanted to check what book I bought in 2015, right? And I need to be able to go back. And it doesn't mean that I need to, we'd love you to shop every single day. But if you were inactive for a little while and then you were going back, then it just creates for a bad experience, right? So that's, I think, one. It's a practical example. The second example, and I think Sunil's heard me speak about this earlier as well, that it is we process a lot of gift cards. I hope a lot of you buy gift cards, and so there is this idea of vicarious consent, right? So essentially, it is a consent first framework that we have with DPDP, and what ends up happening is that when you're buying a gift card, if I'm buying it for someone, then I'm putting in their information, who's the principal there, right? And so it kind of changes, or there is a need to think about, is that a legitimate use case and how would that play out, and so on and so forth. You also have a very practical India-specific example where it's one smartphone per household. And that smartphone is being used to book cabs for the parents and buy a book for the child and watch something on entertainment or go on social media. One phone, one device is being used for all of it. In that case, who's then the data principal, right? So there are very specific examples that need to be thought of. One thing that I won't go into, Rahul, but I think is something that needs to again be further thought of. Is just that in the way that we are moving towards AI models and particularly agentic models, that fundamentally has an ability to change the way we know retail today, right? And how when you come in and you interact with Rufus on, which is our assistant on Amazon, where does Rufus buy and what recommendations are coming your way and so on and so forth. And so that needs to be thought about again, because an agent is doing, it might be taking real-time calls on things or taking decisions on behalf of the principal on different sites and so on and so forth. And and how will consent work there, right? So there are lots of practical examples that need to be thought of. Last thing I'd say is specifically, again, peculiar to e-commerce in some ways. You know, a lot of us feel that e-commerce has been around for a long time. We actually haven't, right? So in India, our marketplace has been around for about 12 years. All of e-commerce in India is barely about 15 years old. And what you have, or what that means is that you have about 7-8% of total retail that's e-commerce today, right? If you even include modern retail and everything else, that's 10-12% of the market, right? What you don't want is folks to get, all of us have become almost indifferent to every time you have to accept cookies. We don't know what that means, but something pops up and we just say accept all, right? And so how that experience comes in for users, how much time there is, what we don't want is the first time e-commerce user getting scared or spooked with number of things that they have to say yes to and so on and so forth. So those are all very specific sort of e-commerce examples, if you will.
So, I mean, I'm going to push back on some of these because, look, of course we want convenience and we don't want to, we want to be able to use Amazon's free web services to be a store of all the books that we've bought. But the law says that you are not allowed to retain data for longer than is required to fulfill its purpose. And when I took this idea to Europe, when I spoke to people in Europe and said that we're going to have a 3-year cutoff on how long you can retain the data, most people said, well, that's sort of how GDPR is supposed to work also. And I guess the pushback to you is if that's sort of the principle. The principle is, look, the customer has not come to see you for 5 years. Do we draw the line at 15? Do we draw the line at 25? Well, you've got to draw the line somewhere. That at some point in time, you've got to delete the data. Sunil is shaking his head because he knows that we always want to know stuff on. I'm going to come to you on this, Sunil, in a bit, because you have a very interesting service. And there is a reason why I think maybe I will have that data. But I'm going to come to it straight after this. But on this, could we not create a system where, and I know that there are a lot of European websites that do this, they will say, you have not come to see us for 3 years. And if you don't come in a little while, we will delete your data. But I'm going to give you a chance to come back. Could we not do something like that to get around this? Because there are lots of websites that I signed up to, and I don't know, and I forgot that I've signed up to it, and it's still holding some information of mine. I would like a reminder that they still have it. Can we think of those sorts of things? And in a similar way, can we think of a little more effort on the part of the e-commerce companies to be a little more respectful of the data that they have on us?
Two things there, Rahul, and I'll let Sunil take this, right? So, but two things I'd specifically say. Number one, so in the rules currently, it automatically says that, right? It does say that you are required to give a notice, so you don't delete things, and you're supposed to send notice 48 hours before, and allow chance for a data principal to be able to say that, look, hang on, I'm very much there, or and that considered activity, and you can continue to keep it. What we are getting at is, look, it's a very legitimate use case. Also, I do think that there is value in perhaps a longer conversation on how much do you trust, and shouldn't the data principal have a certain amount of agency, right? And a data principal can be able to say that, look, I want that to be longer there, and not on the idea that I will respond to an email that might come, and I'll be on a lookout for that email during that 3-year period, and so on. So I do think that there is use case there. The second idea, and again, all of us here would be familiar with it. I think the very notion that you're storing data for many things, and the concept of sort of data minimization now is an old concept, right? It's not data for the sake of data, right? And it's not that you're keeping it just because that allows you sort of a leg up and so on and so forth. I don't think that's the idea here. The idea is, for us, we are a customer obsessed, customer backwards company. You come to Amazon and you are able to, the experience that it created for me, that I can see what I bought in 2015 2015, and it sent me on a spiral, right? Like, because then I wanted to see what I bought every single year, and it became a timeline of my life about different things. But it is something that, you know, as a consumer, the experience that it creates, that's what we are after, right? And so, to your point on, would we have to think through some of these things? Would we have to create some things uniquely Indian? Yes, we will, because that's not what exists everywhere else, right? And so, you know, as an example, what does that mean for, you know, there's a very large, and this is something that might be news to some of you. We have a very large exports business from India, right? So we do D2C e-commerce exports. It's an annual multi-billion-dollar business for us today. Cumulatively, we've done close to about $14 billion in the last 7 years, and we are projected to, or we are hoping to get to about $80 billion by 2030. These are D2C e-commerce exports happening from India to the rest of the world. You know, those sellers being subjected to a certain thing while the seller, you know, the consumer is in the US and so on. So we need to rethink and have a degree of reconciliation with different systems and so on. And again, this particular point is very peculiar, which is the 3-year deletion.
So I'm going to skip to Sunil. Sorry, Sunil. This is not the plan, but it was just too juicy to give up. Facebook has, so just to be completely clear, I have not been on Facebook for over 3 years, and I've also deleted Instagram from my phone. But I did that relatively recently because I'm addicted to Instagram. If I don't delete it, somehow, so I'm going to still give you a little more time on Instagram, but you know, Facebook, I'm off for a long time. But Facebook provides a very, very valuable service. It has a repository of photographs, as you say. I mean, if it's Amazon gives you all the books you want, Facebook's literally got a repository of photographs of your whole life. And I know at least one very poignant situation, which is, you know, when a loved one, particularly a parent or someone dies, sometimes the only repository of that person's memories is on social media. And so as much as inside me, you know, my data protection lawyer's stomach crawls when I think about keeping data indefinitely, the idea that I may not have access to that store of information is at least upsetting to me. How will a company like Facebook deal with this new requirement that is coming, which is a fairly hard implementation of the data minimization principle? Whether it is old-fashioned or not, you know, GDPR still has it. About 120 countries have the same idea. It's not out of the rule book, but this reality is something that I think, so particularly your companies, the companies that you work with, Sunil, have to somehow navigate, and you also navigate it for customer benefit. Personally, as much as I don't utilize it, I know that I will miss it when the time comes.
Yeah. Thanks, Rahul, for that question, and thanks to Carnegie for having me again. Your example perhaps is easy to deal with because there is an exemption for publicly available data. There are conditions for that exemption, and you need the data subject to have made that data publicly available themselves. What this really does for us is it produces a conflict of law situation. Classic conflict of law situations is across jurisdictions or across statutes. And this is perhaps the first time that we have a conflict of law situation within a single law. So it's going to be very complicated to think that through. So let's take a different scenario, which is my dear friend Sunil Khairnar, with the Indian Society of Agricultural Professionals. He has private groups on Facebook, really large ones, tens of thousands of farmers sharing best practices. And even if they weren't doing serious things like sharing best practices, and they were just sharing random memes, all of that is copyrighted material under the Berne Convention. They have rights that they may seek to protect. So I have a deletion obligation in one section of the law, and in the other section of the law, I have a due diligence obligation for all the algorithmic software that might interact with personal data. So I have to write a piece of software, because algorithmic software is every software. There is nothing outside the scope of algorithmic software. And the risks are any risk to any right. So this is their copyright, the right to their intellectual property. And I cannot produce the deletion software to delete those accounts, because it will fail the other obligation that I have on algorithmic software. So I'll most probably turn up at your office and ask for advice on how to deal with these competing equities.
No, but that's not an answer, Sunil. You have to do both. That's literally the way it is. There's got to be some way that...
Under copyright law, it is their IP for, is it 60 years after the death of the author? So I have to hold it for...
You're not obliged.
Sorry?
You're not obliged to hold it.
Why?
Because it's their IP. They can copy it down, they can keep it.
Yeah, they have transferred it to me on a license, and I'm a licensee of their IP. It might be the only version of that IP they hold. The terms of service that they have with me is an expectation that I'm not going to randomly delete their intellectual property, right? My terms of service has no clause which says... So what you're doing really with your sort of vehement agreement with the European stakeholders on this is you're trying to homogenize the digital ecosystem. Ideally, a good law should allow for a variety of private agreements, and all it would do is provide the tests. So there is a private agreement between the user and the platform, and you're just testing whether it meets the data minimization test, whether it meets the purpose limitation test, and that's all you need to do. If you start saying 3 years and 4 years, then you're actually trying to shape technology and innovation in a very old-fashioned and perhaps even regressive fashion.
I want to argue more on this, but I want to take you to another point which is perhaps even more relevant to you, and that is just this whole issue of age gating. India has a very strict threshold on age gating. We think that a child is someone below 18, and that you cannot process the personal data of a child without verifiable parental consent. That's the core provision, and that provision has now been implemented in the rules with something which looks like an age token. We're not fully sure yet what it means, but if in fact we can come up with some kind of a digital solution for this very complex problem, we will be coming up with a solution that perhaps many countries in the world are looking for a very difficult problem. And the way I articulate the problem is that India may think that at the age of 18 we must introduce parental consent, but there is no doubt anywhere in the world, I don't think anyone on the panel will disagree, that at some age, whether it is 15 or 13 or 10 or 7, there is consensus that there is some kind of information that should not be presented to a child. And so the real problem in my mind is, how do you figure out who is categorically below and above? What is, and obviously Meta across its entire suite of products is dealing with this in many different ways. And there are many different age classes that you're dealing with. How do you as an organization think about this very, aggressive framing of the age gating requirement in India, perhaps more than any other country, and have the rules made it better or not? Because we've got a little more clarity in the rules.
Yeah, so I won't comment on the specific age threshold, because I think lawmakers have decided that is the right approach for the country. But I want to sort of draw a contrast between the previous topic we were discussing, where there is a very specific prescription, and the best practice in all regulatory theory textbooks, which is make your regulations technologically neutral, make them future-proof. And this is where the ministry needs our complete applause, because apart from the token, they've left it wide open. You can have an infinite number of compliance options. So that's a wonderful thing that they have taken that approach. And this is an area where having lack of clarity or lack of prescription is a good thing. Of course, there are other areas where that could possibly be a disadvantage. So tokens, of course, represent the best thinking today in computer science. So it's basically a zero knowledge proof. And that's, the government again should be applauded for doing that. If you look at the early work around the tokens, they decided to use verifiable credentials. That's a standard from the W3C, so fantastic. You've decided to adopt a global standard developed at a multi-stakeholder forum. Here the only wish would be, more as an Indian citizen, that the Indian government and Indian academia and also Indian corporations should go to all these standard setting bodies, and also that DPI standards like Bekin should be taken to these standard setting bodies and made part of official work streams at these standard setting bodies. So what's the big advantage if everybody is using token? If a token leaks, then unlike if an Aadhaar number leaks, you know exactly whose throat to squeeze. So accountability is also addressed with the token. So I think what the ministry is saying, this is our preferred approach, use the best that we currently have. But if the state of art continues to develop, then of course do adopt that, and we give you the ability to do so. So that's perhaps the best part of the rules.
Can you tell us how our Facebook experience will change once the token comes, if you do look to implement it?
I'm too low in the hierarchy to even know what we are thinking at this point. So, and perhaps too early also. Yeah, we would most probably wait for the final rules, and then they would get cracking.
Rudy, next GTS, they'll have an answer. Asta, there's been talk about Rufus, and there's been talk about how data can help us. And you've done a lot of work on really unlocking sort of the value of data in a privacy-preserving way. And I'm going to ask you to just reflect on the Data Protection Act as it now currently looks, once we've got the rules and we've got everything in place, for achieving that objective. We have had panels that talk about the value of AI. We've had some closed doors that talk about how India is going to host the India AI Summit, and it's going to be a summit about AI impact. And we're trying to get to a point where we can take advantage of this wonderful wealth of information that we have, except the Data Protection Act puts some very strict safeguards around the grounds for processing the data for other reasons. And I think Aman reflected on some of those concerns, which is that today a data minimization standard and a retention restriction is an old way of thinking about it, which is not aligned with the way we want to go because of AI and all the benefits that come out of that. But I think from a civil society perspective, you have a difficult task, which is you recognize that there's value of data to many communities and the society as a whole. But at the same time, there are privacy and data protection safeguards that have to be addressed. So can you talk a little bit about that in the context, one, of DPDP, but also perhaps use this as a way to reflect on some of the work that you've done on data trusts and those other kinds of mechanisms that we're thinking about?
Yeah, thank you so much for having me, and what a fascinating conversation to just be on. Yeah, I think that the question of like unlocking the value of data is maybe it doesn't belong here. I know that we went back and forth with the various versions of this document to put NPD here or not put NPD here. And
you have to explain what
NPD
NPD
sorry,
means.
non-personal data. So we had a non-personal data moment, which was 3 years ago, where there was a committee that was set up to understand how we could think about unlocking the value of non-human, non-personal, and non-personal was data that was, well, not personal. So I think that there was, and then it was postponed, and because we didn't have a personal data protection regulation, and we had not done a good job of defining what personal data is. And then again, in this in the rules and as well as the act, we have done away with the sort of textures of what is personal data, because we've like lost those categories that we had of what is sensitive, personal versus not. And then I think that what we realized realized through this is that the protection is critical. This is at the individual level. This is about the right to privacy. And I think that the rules as they stand now do a reasonable job. And as we were discussing, that this is an important framework for us to have. The value is in its existence. And I think that we can move on to answer some of the more difficult questions. I am also both excited and as well as a little bit skeptical about the role of the consent managers. And the reason I bring that up here in the conversation of data value is because what we've seen is that in GDPR, there's a right to portability.
Can I just ask you to explain for the uninitiated what exactly the consent manager is? I'm worried that
Should you
we
do
are
that?
talking a language that a majority does not understand.
So the consent manager, and Rahul, you'll have to correct me if I've gotten this completely wrong, is a way to move consent from data principals to data fiduciaries. It has already been implemented in the financial services sector. It's called account aggregator. So you're a data principal, you want a loan from bank A, but you bank with bank B, and the consent manager allows you to do this in a techno-legal way, which is it's a consent layer that moves data and allows bank A to see data to bank B. So that's approximately it. And what the rules have done, it was in the Act, and now in the rules is a big part, is that it has made consent managers a part of the rules as well. What is interesting in the context of data portability is that given that GDPR has the ability to port data, there have been instances where portability has been used, say, by Uber drivers in the Netherlands to port data from the platform to a data trust, which means now if there are 15, 20, 30 Uber drivers that have been able to use this individual right to port data into a trust, they can use that as a mechanism to negotiate with the platform. In the way that I read it right now, the consent manager there's a possibility to do that because we also have a right to delegate, and consent managers have fiduciary responsibilities to the data principal. So to me, that is an exciting framework to see how we can unlock the value of data. I don't think this exists anywhere else, which is that if we are able to use a reasonable informed consent with a fiduciary responsibility at the consent manager, get that data in a reasonable pool, lake, whatever situation, then you're looking at a place where you can actually start to unlock the value of that data, use it for public interest, use it to support the needs of your collective data principles. And that's the big thing that I think that we need to start thinking about, is that right now the DPDP is focused on individual rights, as it should be, and that's how we started thinking about this work. The way that the world has moved since this conversation started is that individual rights are actually a very minor point of exercising this. I think we need to think much more of what are the frameworks through which individual rights can be pooled or collected, and I think consent managers give us a little window of opportunity to do that.
Excellent. Thanks, Asta. Bhuvneshji, you're here. I actually don't mind if you sit in the audience for a bit, because I do want you to come up towards the end, and actually you've heard these gentlemen and ladies speak about this many times. You know all their arguments, so I don't think they're saying anything new to you. But we do want to hear at this particular point in time, where are we with the rules and what is going to happen coming forward. So let him have a glass of water and rest. He's come in a hurry. Sanya, I want to just pick up on account aggregator, just to think. So now we're going to do a bunch of sort of quick questions. Is the account aggregator framework that is one of our signature DPIs, has it got the protection it needs within the Data Protection Act? Are there any concerns? I know in the industry they feel that they are caught between two stools because they're both regulated by the RBI and now potentially by the Data Protection Board. So any such concerns in the industry around our signature data sharing DPI in the context of the new rules?
Sure. No, thanks for that. And actually, I'm going to pick up with a slight point of distinction from what Asta just said. One framing is that consent manager is the genus and account aggregator is the species, right? That is one framing of it. But there's a slight distinction over there. Account aggregator as a framework came into place prior to a Data Protection Act having existed, and from the vantage point of the financial services regulator. What that ended up becoming was the account aggregator framework tried to govern movement of data between two entities, not necessarily as a function of the consent of the individual. Definitely, there was no privacy notice requirements, and then there was a requirement of consent being the trigger with which data is moved. But the vantage point from which it is evaluated is the movement of data. If you look at the definition in the account aggregator framework, actually, even the TPAP data, which is like a Google Pay, Phone Pay, their activity of showing you your bank balance statement on your last few transactions could get caught within the definition of the account aggregator framework, which we know makes no sense and is not the intention of the RBI regulations. That is part of the restriction of when you're trying to define a species without the genus existing. And that's how account aggregator framework came about. The utopia I see is that the account aggregator collapses within the consent manager framework, that RBI within its definition or within its wisdom can always require a couple of responsibilities over and above, but there should be a singular framework that exists. Apart from the elegance of the legal operations, also of course the major flaw or the restriction in the account aggregator framework is the business functions, which the consent manager framework does seek to address, if not completely solve. So in that world, that's what I would like to see.
I mean, I have never heard of the RBI giving up a fiefdom that it has, so it is a utopia. Aman, very quickly, just to go back to how this fits into your global operations. I know that there are new provisions that could potentially apply to cross-border data restrictions. Are you guys concerned in any way about it? Because it applies to significant data fiduciaries, good chance that you will come within that. Of course, it doesn't apply right now, but in a global business, are you concerned about Rule 12.4?
I think, and again, Bhuvneshji is here, and he's been very, very kind in both in private conversations, but also in consultations, being very, very clear. And I think we understand the intent of where it's going. And so I think, look, a lot of the rules will become clearer in its implementation, and that's why we think that, while the government has said that, there is a 2-year time frame, I think thinking through perhaps a staggered implementation, thinking through, perhaps even longer implementation, will just allow us to understand the exact ramifications of all of this. It is difficult today to emphatically say, no, we are not worried. Because the way the language is written, it is something where there could be potentially restrictions. We also need to see what the committee comes out with and talks about. There is that sort of and it has listed various reasons, but those reasons are fairly wide on what could eventually come under the ambit of hard localization. We don't know that as yet. So I think those things will become clearer once the implementation starts and once we have various ways. I think to the government's credit, what's been great is that they've been very open to both suggestions, but also just going in and having a conversation saying, this is what we are thinking, or this is what we understand. Is that what you are thinking as well, and so on and so forth. So I think that's where it will become a little bit more clearer.
Asta, very quickly, and Bhuvneshji, whenever you're ready, just come on. Don't feel...
we can all go back in the audience then.
No, you sit here. Asta, just very quickly on Data Protection Board, any concerns around redressal, any of those sorts of things from a civil society perspective? Are there things that, Bhuvneshji is now on stage, so you can actually ask him directly for the things you want to change.
Yeah, first of all, carrying the whole burden of civil society is very hard. But from my perspective, I think what we're concerned, the messiness of India, I think, is what has been brought out, right? Like, how do we make sure that a digital-first board really gets all the complaints in? Is it going to be cumbersome? Is it going to be accessible? Is it going to be independent? And I think we were discussing this before, is that I think that the first constitution of the board really matters in setting the tone of what is going to be, and how do we create the sort of tone and tenor of what's going to go forward. But again, I think questions of accessibility are really coming up, and I don't want to be in a situation where people have grievances and are not able to bring it up because the board sits elsewhere and is only being mediated through digital means. So, yeah.
Sunil, anything that is going to constrain you as a significant data fiduciary other than the things that have been discussed? You're free to say no, then Bhuvneshji's job is done easier.
No, I think the other obligations such as DPIA and audit, etc., are pretty standard, and Meta does have similar obligations in other jurisdictions. But I wanted to sort of talk about something slightly separate, which was back to the exemption for publicly available data, and there we are significant data fiduciary because we train llamas, and most recently Llama 4. I think the intent was to provide an exemption that would allow for ML training. I think that was perhaps the goal. Though in the details, there can be challenges, especially for a data fiduciary to verify that those conditions are met when the data is from the publicly available internet. So a sort of small modification which allows the fiduciary just to test if the publicly available data has been legally made available rather than made available by the data fiduciary, data principal himself or herself. I think that would be the kind of small tweak. Of course, that is something in the parent statute, not germane today because we are discussing perhaps the rules more than the statute, or we're discussing both.
We're discussing the data protection framework as it's a complete framework now.
Yeah, so if that were to happen, then some people believe that with Section 52(1)(c) in the Copyright Act and this exemption in the DPDPA, India would become perhaps the most friendly jurisdiction on the whole planet for you to bring your data centers and train your models. So we're hoping that's roughly where we will go, if that is possible.
I think copyright is still a way out, but certainly this interpretation, and certainly if the government can clarify this, because this single thing from really leveraging AI is going to be really important. Bhuvneshi, we've had a long discussion. You've heard over the many consultations that you've had across the length and breadth of the country. I can certify that at least in the two that I attended, there have been no new points that have been brought up on the panel. So, so you know the answers, but I just want to want you to give us a state of play right now, because the consultation period is over. Last I heard, you had received some 6,000 or 8,000. I don't know what the final thing is. It may be 10 or 14, but if you can just tell us how many comments have been received, a broad sense of how the comments, what sorts of comments they were, and if you can, what reflections you have as to how they will be reflected into the rules.
Thank you. Thank you for having me over here. One thing, it helps us in understanding how the various stakeholders think. It's a great source of feedback. And at the same time, it provides a platform about telling how the government is thinking about a particular thing. So it's a two-way communication, it really helps. So you've been part of it, and many of you would have been part of the consultation we had, the consultation in physical mode. And across the length and breadth of the country, we did one in Delhi first, then we went to Mumbai, we went to Bangalore, we did it in Kolkata, we did it in Guwahati, Hyderabad, and of course back in Delhi again. And smaller in-house consultations also, individual references, people coming over and talking one-to-one, a lot of industry people coming over. So I personally think that it is one of the most comprehensive consultation ever on any rule-making process. I'm sure you would agree with that, perhaps. That kind of an open process perhaps might not have been followed earlier, but this time it has been ensured. Even during the act also, I personally think the consultation was very, very wide. We received about 20,000 plus comments. And here again, we have received more than 6,000 plus comments. And the nutshell is what we have discussed in most of the consultation meetings. So there's hardly any change. In fact, what we had requested the stakeholders in those meetings who had come physically to put it in writing and send it to us. And in case they had any suggestions, they could come back with the language also, and they wanted certain concerns to be addressed. So we have received that, and apart from whatever we received on MyGov, I think we received about 100 odd detailed representations, giving very, very detailed comments on every rule, the concerns they have. And we have gone through the process, analyzed all of those. I think we are ready, and a little bit of legislative process, the vetting and all those things should be about 6 to 8 weeks. We should be finalizing it. 2-3 things which come at every platform, and again being discussed here. I think I'd like to give examples for that and then come to the need perhaps, and hope you understand. Let's say there's a person who goes and stays in a hotel, commits a crime, and under the DPDP empowerment, next day he asks, please delete my data. That's the provision. Please erase. He's got the right to be forgotten. So how do you ensure that it doesn't happen? That at least data is maintained for a certain time, because there is an investigation which has to go and that data has to be needed for investigation. How do you ensure? So you ensure it through the rules only. You have to create an enabling provision by which you ensure, no, the data, such kind of a data will not be deleted the next day, and it has to be kept. So you create a provision there. Then let me give one more example. Suppose there is a significant data fiduciary which is processing the data related to defense of India. Okay. Now, you as a government, you want to put an additional restriction because it's a defense data, it's a very, very sensitive data, a strategic data, and you don't want it to be treated as a general regulation thing. And that's where you want to bring in and say that, okay, in these kind of a scenario, we'll have a committee, that committee will look into this. And of course, this committee is not going to do something, behind doors suddenly and come out with a notification one fine morning. No. Of course, the committee will meet, there will be a notification, just like the consultative process which has been gone into the rules, that kind of consultative process will be followed for that committee also. And of course, people will have the right to say and tell that, okay, no, this is my concern, or this is not my concern, this is okay, this is not okay, this is how we are concerned. And this is my global business, or this is my domestic business. So obviously, then it follows the consultative process and reaches a final conclusion. But you need an enabling provision. If you don't put it today, then you come back and amend the rules. Right. Let me come back to third thing. Now, in most geographies, you would agree, we already have the examples from the GDPR and the other privacy laws across the globe. And even before these privacy laws were there, the sharing of information from the law enforcement agencies to other law enforcement agencies, or maybe personal data of people from one repository of data to the other government or the entity of the government, usually gets governed through something called MLAT. Correct, isn't it? Is there. So what is being said is that if a foreign entity or a foreign government entity, it's only about foreign government entity, foreign government or its entity, is asking for the personal data of Indian citizens, which is available with a data fiduciary, it will be governed by the directions, which in any case is otherwise governed by MLAT. So, this is an enabling provision for creating something like an MLAT to be enforced. So, these are basically 1, 2, 3, all enabling provisions to be used in particular scenarios. If the provisions are not there, then there is a handicap. And of course, the sovereign right is there, and the sovereign has the right to create those provisions either through the legislation or through the rules. And the rules have to come from the act, and there has to be an enabling thing in the act. That's where the rules will come from. So I think I'll take a pause here. I'll stop here. Receive some responses from you, or maybe anything else you want to ask.
The one thing you've been consistent about is these examples, and I think we've heard it. The only reflection that I will have, which is once again, I hope I am consistent about that to you, is that as much as the logic of the fact that you have put this in to enable future action makes sense to us, it's also broad, and as we look at it, we say, if you enable this, what else can you enable? And that's where everyone's getting worried. But I'm not going to agitate that thing again because we don't have much time. I want to go to the next and perhaps most important thing. You said 6 to 8 weeks. What's the next steps? Are we going to immediately see the Data Protection Board notified? Are we going to see some kind of a transition period for organizations to get ready? I keep telling my clients, including the ones on stage, you don't need a transition period. This has been around for 2 years. You should have been ready by now. But are you going to be more generous, or are you going to, what can companies expect?
Thank you. Thank you for raising that point. I think requires a clarity. Recall the first Delhi round of stakeholder consultation. Honorable Minister was present, and he had categorically remarked that sufficient time will be given. Sufficient time will be given. And when you say that you have been around, you have read the act, you have read the rules, and you should have been ready, it may apply to some of those who are sitting in this room, or maybe are the tech companies who are conversant with this in other geographies. But this law doesn't apply only to them. This law applies to MSMEs. This law applies to perhaps the single shop owners. A pharmacist who runs a computer and keeps the data of the individuals on that, it will apply to that individual shop owner also. So, and they are not ready. And none of them have a past experience of any other geography. They need to be prepared. They need to have solutions. The tech industry needs to, and the legal side also, both tech and legal together, need to come out with practical solutions, how it actually needs to be implemented by the data fiduciaries at all levels, not at just one level. So all levels, some people may be geared up before, some people may come up later. So one way is that you don't apply it to certain categories, you apply only into certain categories and make a distinction that, otherwise you give sufficient time for everybody to come on board. And you have to keep in mind, I think, the biggest data fiduciary is the government itself. And the government needs to be prepared for that. So not only that, the MSMEs and the smaller businesses need time. The government itself also needs time. And we have huge databases spread all across, not only the central ministries, at the state level also. And we have been working in-house. So that means there will be definitely a sufficient time which will be given. Of course, that time will be utilized for bringing in the Data Protection Board in place. And whatever time is fixed, I think we should bring Data Protection Board a little bit in advance so that the board is also geared up when actual implementation starts and it's ready. We have gone in-house and created the digital platform for the Data Protection Board. As we mentioned, this is going to be a completely digital office. So that part is being readied, and all other processes are in pipeline. And I'm sure, looking at the timeline that comes, we'll set up things as and when needed, and much before that it is needed.
Thank you, Bhuvneshi. Thank you, all the panelists. I just want to also commend actually everyone in the whole ecosystem, not just the government, but this has in fact been one of the most interactive and cooperative legislative efforts that we have done in the country, in my personal experience. And we are getting to a place where I think we're all comfortable with what we are going to see, and also confident that we will be able to, even if there are problems, which there will be, find a way through it.
And I'm confident that even in future also, anything which comes will go through similar kind of a process.
Thank you very much. Please put your hands together for this wonderful panel.
Thank you all for a well-rounded and thoughtful conversation on India's approach to data governance. May I request the audience to please settle down. We now move to our next panel, DPI, the new marketplace.